We'll now turn to constitutional law. We covered the American legal system earlier, which was a timeline for some of the major events of the establishment of the U.S. government and our legal system. And now we're going to dig into the Constitution itself. I spend more time on this than most business law professors, I'm sure. And part of it's because I love history, but part of it is I really do believe that Americans are woefully ignorant in general about the Constitution. And some of these provisions and some of these fundamental concepts we're going to talk about, not only are they interesting and relevant to our citizenship duties, and especially in election years, but also it relates to some business things in ways that some people may not be aware of. So, without further ado, this is the first page of the Constitution, the preamble, "We the people." And as I may have touched on already and will touch on again, I'm sure, this phrase, "we the people," has significance. It can be argued that the single most important issue in American history, legally, now I'm talking about legally, under the Constitution, is this federal versus state power. It's the battle we've had. I mean, obviously there were some horrible things about slavery that women couldn't vote, we'll talk about, but we have been fighting this battle about federal versus state power since the beginning of the country. And some of that turns on this phrase, "we the people," and I may dig into that a little bit later. But that is the preamble to the Constitution, and it begins with Article 1. What I want to turn to initially, before we're going to have some background things, then we're going to talk about some federal power issues versus state power issues specifically, which was hearkening back to the doctrine of reserved powers, the doctrine of enumerated powers. And then we're going to talk about some of the specific constitutional clauses that Congress uses and so on. And then eventually we'll begin on some of the Bill of Rights. And we're going to spend a lot of time on the Bill of Rights. It pretty much takes up all of Part 2 and a little bit of Part 1. I think an important thing in understanding the constitutional debate is this idea of interpreting the Constitution. There has been a lot of disagreement and debate over our history about how the Constitution should be interpreted. And it's more complicated than even I'm going to be able to explain in this few minutes here. But there are two basic approaches. Now, these aren't written in the Constitution. These are just two approaches that have evolved over time. And we're going to talk about each of them and how it plays out today. The first one, strict constructionist, sometimes called, other times called originalist, is a position that is taken by many conservatives and political conservatives and some libertarians, but certainly the conservatives. And the intellectual leader of this approach was Justice Antonin Scalia, who is now deceased in the Supreme Court. And he talked a lot about it. Here's the basic idea. In a legal system that values predictability and consistency, so that we can all know what the law is and that we can conform our behavior and so forth, it is very important that we have consistent interpretation. And the best way to do that, based on the Constitution, is to try, as judges, to interpret and apply the words themselves from the Constitution. In other words, what was the intent of the framers? And this is a constant mantra. What was the framers' intent? Now, Justice Scalia himself would say it's not so much what the the framers intended. It's a law. Here it is. What does it say? Let's try to apply it the way it's written as much as we can, 230 plus years later. And that's the basic idea. So, and some people call it textualist, from the text. Well, the problem, of course, is the Constitution in many places is vague, deliberately so, I think, in some cases, general, and you'll see examples of this. And the words themselves that were used are very old, and some of them have different meanings today. So the criticism against the strict construction approach is that things have changed. Now, the modernist approach which is that advocated by many liberals on the court and other judges around the country, is that the way to think about the Constitution is not as something engraved in stone. It's not a secular gospel, and never was intended to be that. It is a set of guidelines, general principles, and that's why it's general, and that's why it's vague, and it has to be flexible. And a phrase that's used is this idea of, and I want you to remember this phrase, a living, breathing document, that it can change, that is, the meaning of it can change over time, that we should interpret it based not on the language and the intent of people who lived a long time ago, but based on general principles like free speech and so on, applied to today's social issues. So the modernists would argue, how could the framers have possibly anticipated nuclear weapons, automatic weapons, when they're thinking of gun control? How could they have possibly contemplated the technology we have today for hacking into computers, when they were thinking about privacy issues and so on? Same-sex marriage, segregation, social attitudes change. That's the modernist view. It's a big split between the court, the conservatives on the one hand, the liberals on the other. It's not so much that it's a right or wrong, but it is a very different approach. Now, let me go back to strict constructions for one moment. In order to glean the framers' intent, in other words, if we can't tell from the words themselves what was the intent, we have to dig back to what they argued and believed when they wrote the Constitution. And this is where the Federalist Papers by Madison and Hamilton and John Jay, and Madison's notes of the Constitutional Convention are so critical because they are deemed to be the most reliable sources of what the parties, the framers, argued, intended, and so on. And I would say, and I think most people would say, that the Federalist Papers are the single most important document in our legal history outside of the Constitution or since the Constitution, because of the respect or the incredible amount of complexity and detail in them about what the arguments were at the time. So remember that. Federalist Papers, a big deal. Now, turning to this federalism idea, we talked a little bit about the doctrine of reserve power, the doctrine of enumerating power. We're going to dig into that a little bit further now. And this federal versus state thing is and continues to be a huge issue. Since our beginning, there have been people who've advocated strong states' rights, limited federal government based on the doctrine of reserve power, and then other people have argued for a strong central government. As I've already mentioned, I believe, Jefferson founded one of the two first political parties, the Democratic Republican. Jefferson was a states' rights advocate, very much so, in fact. Hamilton founded the Federalist Party and was an advocate of strong federal power. Today, the parties have kind of changed. Some of the parties have died and reestablished, but today the Republicans generally are advocates of state rights, and the Democrats are advocates of a more strong central federal government, although they've both been inconsistent, as I will probably point out at different times. So let's kind of go a step further on this history of federal versus state power. There are those who argue that the Civil War was fought not over slavery, but over state rights. Many people in the South, certainly at that time and even today, will argue that. Now, it's an unanswerable question in the sense of, well, what was the Civil War fought over? It was actually fought over many things, but clearly slavery was at the heart of it. But because slavery was in the South and not in the North, it became a federal versus state argument, because if you're in the North and you're opposed to slavery, then you don't have too much trouble with the North telling the South, at least the argument was, to abolish slavery, and vice versa. So, but let me give you a little background some of you may not be aware. The Civil War was not the first time where this idea of states sort of reclaiming their authority under the doctrine of reserve power. And it really began actually in the 1790s, shortly after the government began. But certainly by the 1820s, there was a movement. It started in South Carolina, but was also present in other southern states, for something I want you to remember called nullification. Nullification is the argument that in our system of government, the states are essentially sovereign. They are part of a loose confederation, almost like an international treaty, and that if the federal government usurps the rights of an individual state, if the states disagree, by the majority of the state disagrees with a federal law, the states have a right to nullify that federal law. Now, it's a very complicated issue. I've done a lot of research on this for a project, but at its root, it means that the states can refuse to allow the feds to come into the state to enforce it. So if a state was opposed to a tax, for example, the argument would be the states could literally prevent, through the state militia or whatever, the federal government from enforcing that tax. And that's what happened in South Carolina in the 1820s. It actually began over a tariff, of all things. And the leader, and I want you to remember this name, he is considered by many to be one of the great legal thinkers in U.S. history, John C. Calhoun, even though his views are largely disagreed with today by many people. But Calhoun was the intellectual leader of the nullification movement, and a senator from South Carolina who became vice president of the States. And that's what he was arguing, that South Carolina didn't have to follow the federal tariff that was set on exports. So, or excuse me, on imports. Anyway, so nullification sort of became the concept that led later to secession during the Civil War. Now, this idea of enumerated powers, okay, the doctrine of enumerated power, to sum up, is the idea that the federal government, and this was generally agreed upon, was a limited government, that its powers could only come from things specifically spelled out in the Constitution, in other words, listed or enumerated. What that means as a practical matter, what I want to focus on now, is that the Congress and the federal government cannot make laws binding on the citizens, in other words, on the states, unless it has authority for that law specifically spelled out in the Constitution. And then what that means is for Congress to make a law, it needs to point to a clause in the Constitution that gives us that authority to do that. James Madison famously said in the Federalist Papers that the Constitution was set up a government of limited powers, and talked about this at some length. Now, here are some of the clauses in the U.S. Constitution that Congress relies upon when it passes a law, for authority to pass that law. It doesn't always say so in so many words, like, hey, here's the clause that we're relying on. But the argument that it has that in mind, and then if it's pushed in court to justify it, it will then explain. We're going to talk about the first three: Supremacy Clause, Commerce Clause, and Taxing Clause. I'm not going to talk about the other two in this class, and we're only going to briefly touch on the Taxing Clause. Let's begin with the Supremacy Clause. This is the Supremacy Clause, or at least excerpted. And this is an example of how general and vague the Constitution can be. This Constitution and the laws of the United States shall be the supreme law of the land. Now, on the face of it, that would indicate that federal law is all-encompassing, trumps all state law, period, end of story. Well, since the beginning of our history, it's been very clear that our founders and framers didn't really intend it quite that broadly. And we know that from the Federalist Papers and other sources. So the way it's been interpreted is that in matters of national significance, I mean really big deals, there are times when the 50 different states with 50 different state laws and so on is an unwieldy situation, and because of national public policy, war, crisis, the Depression, whatever, Congress needs to step in and take over in a particular area of law. Quick example. In the 1970s, there was a pension crisis in the United States, and a lot of companies were raiding their pensions for employees because they needed the money, and there were no laws to restrict them, and then the pensions went broke. And Congress, up until that time, it had been left to the states to regulate pensions, and Congress stepped in and passed a law called ERISA, remember that, ERISA, E-R-I-S-A, that regulates group insurance, group health plans, and pensions. And Congress basically said the states are doing a terrible job. This is a national crisis. We're going to step in, and the word for it is preemption. Congress will preempt or substitute its laws for the state laws. The states can no longer regulate this area. And that's the basic idea of the Supremacy Clause. The strange thing about the Supremacy Clause, I think, is that Congress rarely uses it. It's a card it doesn't play very often. Probably doesn't know how to play its hand. Now, the Commerce Clause, on the other hand, is clearly the one that's used the most for business regulation. This is the Commerce Clause, the entire Commerce Clause. Congress can regulate commerce with foreign nations and among the several states. Okay, there's an example. What do the framers mean by that? They didn't explain it. But it's pretty well understood what they meant, because when the Constitution was being written, the two major issues, and this goes back to the Revolutionary War, that almost all the delegates agreed on that were important for a federal government was national defense. The states were too small to defend themselves, and export-import, sort of commerce among nations, but also among the states. There had been a lot of frustration before the Constitution by how individual states were setting tariffs as opposed to other states, actually charging more goods. Like if New York were shipping goods into New Jersey was charging a tariff on New York goods so that to favor New Jersey businesses, and everybody recognized that was not workable. So today the Commerce Clause is applied in two situations. It's very, very broad. The first is it is the one that Congress uses the most to make federal laws, thus doctrine of enumerated powers. And the second thing is the Commerce Clause is used because it clearly says Congress has the power to regulate the commerce between the states, interstate commerce, that if a state makes a regulation or law that is unfair to residents and businesses of other states, and they can't really justify it, then the Commerce Clause can be used to invalidate the state law. And I'll give you some examples of how that works. So let's begin with the first aspect of the Commerce Clause, which is the power of Congress to make laws. One of the most famous cases in U.S. Commerce Clause history is a case involving this guy. It was called Wickard versus Filburn. And now I'm trying to remember, but I think his name was Mr. Filburn. But anyway, he was a farmer. I want you to remember the case name. It was Wickard versus Filburn. This is back in the Depression. And he was a wheat farmer in Ohio, in Claremont County, Ohio. You can see where that is on the Ohio map. He grew wheat. We were in the Depression, and wheat prices were very low. Congress decided that one of the things it needed to do to get out of the Depression is to increase demand and decrease supply. If it could do it, that would drive prices up, and that would spur money in the economy and so on. Now, it's kind of hard to increase demand, so what you do, if you're a government, is you decrease supply. And so what Congress and the federal agencies did is they put some caps on how many pigs you can raise and how many cows you can raise and how many bushels of wheat you can grow on your farm. Well, he ignored that, so whatever the cap was for his farm, bushels per acre, he simply ignored it, and he went way above it, and he was fined by the federal government. Went to court, and his argument was that this was an unconstitutional act of the government because he was not impacting interstate commerce. He grew his wheat on his farm, sold it to local grain elevators, and some of it he kept on his farm to use as seed for the next year's crop. Believe it or not, the federal government actually fined him for growing too much wheat that he himself was going to use on his own farm. He wasn't even going to sell it. It went to the Supreme Court, and the Supreme Court held that Congress had the authority under the Commerce Clause to issue this regulation. And the argument went something like this. We're in a depression. This is a big deal. If Congress can't regulate this guy, it can't regulate wheat. And Congress is going to be handicapped in trying to impact the economy. But the real key to this decision was he was arguing essentially but I'm not selling it out of state. I'm not selling interstate. And the court said that doesn't matter. You impact interstate commerce because you put your wheat in a grain elevator along with a lot of other wheat, which then which goes out of state, makes bread shipped out of state, and it's the impact on the economy nationwide across state line that what really matters here. It's a very controversial case. It is still considered the broadest the court has ever gone in application of the Commerce Clause. Okay, this is a really big deal. It is still considered the broadest power that the courts have ever allowed Congress in invoking the Commerce Clause. Now, let's move ahead a number of years. For many, many years, there was not a single case in which the U.S. Supreme Court held that Congress went too far. In precedent of Wickard versus Filburn, the court was basically just letting Congress do whatever was the feeling. And then after some of the school shootings, the Columbine, those kinds of things, in the 90s, the U.S. Supreme Court had a case involving an act of Congress in which Congress, in trying to do something about school shootings, had made it a crime, a federal crime, to possess a gun within 1,000 feet of a school. Now, not in your home, that would be okay, but like literally out on the street. So if you had a gun and, I don't know, you were walking down the street or whatever, driving around with it, and you're within 1,000 feet of the school, you could be arrested and charged with a federal crime. It was challenged to the U.S. Supreme Court, and the court held that this was too much, that Congress could not rely on the Commerce Clause for this. The court said schools are primarily for local regulation. And this case didn't involve the sale of guns. That would be commerce. It just involved the possession of guns. They bought the guns legally, the people in question here, very often. And the court said interstate commerce means commerce, regulating the sale of a product. And therefore, because there was no regulation of the sale of product, just possession, this is a matter for local government, and the court struck down this federal law. So that began a little bit of a left turn, or right turn actually, in U.S. Supreme Court cases on the Commerce Clause. Now the next really big case on this issue involved medical marijuana. Now, some of you today have the perception that marijuana is illegal and it's all cool, no problem. Well, that's not true. Congress, many years ago, passed the Controlled Substances Act, which is a federal regulation of drugs. And there is something called Schedule I drugs. Schedule I drugs are considered really nasty and high priority and are not considered medicinal, as opposed to prescriptions and some other things. Marijuana has been and remains a Schedule I drug, meaning that the federal government could arrest somebody for possession or selling or growing of marijuana. And that's still true. A lot of people don't realize that. This woman in the upper right-hand corner and a couple other people were residents of California who brought a lawsuit. They had illnesses, and they said the only way their pain could be alleviated was to take marijuana, to smoke marijuana. Not in synthetic form in a pill, but to smoke it. California was one of the first states to have a medical marijuana law, which made it legal for a person with a medical marijuana prescription to grow their own marijuana at home up to a certain level. And as long as they didn't sell it to anyone else and used it for their own use, they could grow up to a certain number of plants and use it. And it was legal under state law. One day, she gets a knock on the door. It's some drug agents from both the federal government and the California state police authorities. And did a search warrant. We hear you're growing medical marijuana. And the woman said, well, yeah, there's my prescription and it's legal. The California authorities searched the house, concluded that she was within the California law. She was not growing too many plants. She was using it for medicinal purposes. They left. Have a nice day. The feds, the DEA, Federal Drug Enforcement Agency, said, not so fast. We're not going to arrest you. We could, under federal law, Controlled Substances Act. But we won't. But we are going to destroy your plants and don't do it again. And they left. She challenged it, and her argument was that here is the federal government regulating what is really a state medical issue. Medicine is usually licensed on the state level. And what she said is California has decided as a state that it's okay to have medical marijuana. And now the feds are trying to override that, preempt it. Went to the U.S. Supreme Court, and the U.S. Supreme Court held the feds can do this. Now, here's what's interesting. A couple things. The precedent in this case, which is still the precedent in the United States, is that the federal government can, through the Controlled Substances Act, regulate marijuana, can arrest people who are growing it, selling it, etc., can override state law, and that's even for medical marijuana. It doesn't even, you can imagine what it's like for recreational use. So how is it that Colorado and Washington and some other states have legal marijuana? Well, here's what it boils down to. The Obama administration made the decision not to use the federal government to override state laws. They wanted to see how it went. Colorado and Washington are experiments. The federal government can still, if it wants to, shut it all down. And just days ago, I read something where the federal government has reinforced Schedule I marijuana. So the story is not over yet. And that takes me to, without question, the most important case on the Commerce Clause in many years, which is the Obamacare case. That's what people refer to it. The Affordable Care Act is the official name for the law that requires people to have insurance. And the issue in the case was the individual mandate that requires everybody to have insurance. And if you don't have it, you can be taxed, have to pay a tax. Now, the rationale behind it and how it works is incredibly complicated. There's a lot of misinformation out there still about the legality of it. I'm just talking about the constitutionality of it, not whether it's a good idea, whether it's working, etc. That's for my insurance class. Here's what happened. Congress requires everybody to have health insurance, effective 2010, 2011, I'm trying to remember. And if you don't have it, you can be taxed. You can be required to pay a tax. Now, when Congress first wrote the law, there was some change. It was called a tax, and it was called a penalty, and Congress was all over the place on whether it was a tax or penalty. The bottom line is you have to pay a tax through the IRS if you don't have health insurance, unless you're exempt for some reason. Well, a lot of people challenged that law. There were many different lawsuits on the constitutionality of the individual mandate, and it went to the U.S. Supreme Court. And the argument that most people, including myself, anticipated, and it was in fact made, was that this effort by Congress to make people buy health insurance was not valid under the Commerce Clause. In other words, Congress did not have the authority under the Commerce Clause to, quote, make people buy something. Now, I predicted, and I think most lawyers did that I knew of, predicted that the court would rule 5-4 that this was not supported by the Commerce Clause. In other words, I predicted that the court would strike down the individual mandate on the grounds of the Commerce Clause, saying it's not supported by the Commerce Clause. 5-4. And the reason I thought that is because there were 4 solid conservatives, 4 solid liberals, and Justice Kennedy is generally a swing vote. I was right. The court did indeed hold 5-4 on the Commerce Clause that this was too broad. And the rationale was the Commerce Clause has never before been used to force people to buy something. It has always been about regulating an existing market where people are buying something. And it's something, frankly, a lot of us hadn't really thought about. Now, Justice Scalia made a point in oral argument that everybody laughed about, but it ended up in the written opinion. He said to the lawyer for the government, who was arguing for the support of this law, saying, now, if Congress can make people buy health insurance now because we have a health insurance crisis in this country, what is to say that Congress couldn't make people buy broccoli because broccoli is good for you, and if everybody ate broccoli, it would reduce obesity, blah, blah, blah. And everybody laughed. But it is an interesting point. Where do you draw that line? And the court, in the Sebelius case, said, we don't want to open the door to Congress making people buy things. That's kind of a scary thing. So I was right on this. Just one problem. Me and a lot of other people did not take into account what was considered to be a very minor argument by the government, which is that the individual mandate could be upheld on the constitutional grounds under the taxing clause. Congress has very broad power to tax us in order to raise money to pay for a system involving a national crisis. And in a 5-4 vote, the U.S. Supreme Court said, yeah, this is within the taxing power of Congress. And immediately, a lot of people on the right said, okay, Chief Justice Roberts, upper right-hand corner, he was the swing vote. They said he should be impeached. He's a conservative. What in the world is he doing here? And a lot of people said, how is this? They can say it's not supported by the Commerce Clause, unconstitutional, but it's okay under the taxing clause. What's with that? Well, for our entire history, there is a principle of law that, and Chief Justice Roberts wrote in the opinion, that Congress's role in the balance of powers, the court's role in the balance of powers is not to determine whether a law is good or bad on public policy, but whether it's constitutional. And if it can be held constitutional under any clause, then the court's job is to say it's okay. And that's what they did. And what they said is the taxing clause is much broader than the Commerce Clause. So there you have it. And what I want you to remember for quiz potentially is Chief Justice Roberts was the swing vote. All the other 8 voted the same. That is, 8 of them voted that it's unconstitutional on both clauses. 4 of them did, the conservatives. The 4 liberals voted that it was constitutional under both clauses. And Roberts voted no on Commerce Clause and yes on Taxing Clause. Now, and therefore the individual mandate was upheld. We still have the law. Let's move to the second aspect of the Commerce Clause, and that is the purpose. One of the purposes of the Commerce Clause is to prevent states from using excessive power to make laws that treat citizens of other states unfairly. Now, this is a complex issue. It's not that every state has to treat non-residents exactly the same all the time as it does its own residents. But we live in a country where freedom of travel across state lines, shipment of goods across state lines should be relatively equal. Think of it like free trade among the states. And that was a huge issue to the framers. As I said, there were some issues at the time about New York and New Jersey having this battle and charging high tariffs on goods coming from other states. They didn't want that. So the effect of that is if a state tries to pass a law that unfairly restricts business from another state and so on, that law can be stricken under the Commerce Clause. There are 2 pieces of this. This is how it works. If somebody challenges a state law on Commerce Clause grounds, in order to win that challenge, the plaintiff would have to show, number 1, that the state itself, the state that passed the law in question, has a legitimate public interest. That's the phrase, legitimate public interest. What that means is that it has a good reason for passing the law. And even if it has a good reason, that law will only be upheld if the impact on interstate commerce is incidental, meaning minor. Think of it as a materiality test. Okay, I know this is kind of complicated. I used to cover a couple of very old cases. I've decided recently that probably this case makes the point pretty simply and as well as any of them. This is a 2005 U.S. Supreme Court case involving wine, and it really illustrates the problem. Michigan and California, I believe, were the states involved, but Michigan was the featured state. But the point is, a couple of states passed laws that basically taxed shipments of wine from other places into their states at a much higher rate than Michigan wineries. So think of it as if a Michigan winery were selling wine to Michigan residents, the tax is X. And if Virginia, we have quite a few wineries here, if a Virginia winery tried to ship wine into Michigan to be purchased by Michigan residents, the tax was 3 times X, much higher. The intent was clear. The state of Michigan was trying to favor local wineries for economic development. Well, as you can imagine, wineries from other states said, this stinks, and they brought a lawsuit. It goes to the U.S. Supreme Court. And remember, the test is, number one, did Michigan have a good reason for this law? I mean, was it a public policy reason for public health, safety, welfare? And the court basically said, no, it didn't. We can't think of any legitimate reason. I mean, Michigan tried to come up with some arguments, but the court's saying, we don't see how this has any basis for the public health, safety, and welfare of the people of Michigan. Wine is wine. You may like a wine better than another, but wine is wine, whether it's coming from California, Michigan, whatever. Secondly, the court said, even if you did have a good reason, we will not uphold the law if the impact on interstate commerce is more than just incidental, minor. This is not minor. There's a significant surcharge tax on out-of-state wine, and it's penalizing interstate wineries, and it's penalizing the citizens of Michigan and limiting their choice. The court struck the law down. And here is a quote from the case, and this, I think, just really capsulizes it very well. States may not enact laws that burden out-of-state producers or shippers simply to give a competitive advantage to in-state business. This mandate reflects a central concern of the framers that was an immediate reason for calling the constitutional conviction. The conviction that in order to succeed, the new union would have to avoid the tendencies toward economic balkanization that had plagued relations. In other words, the court said this is one of the core principles of the Constitution. You can't do this. We're going to try to have this fair trade and free trade as much as we can in the United States. So that's an example of how it works. Now, I'm moving on now from the power of Congress and the Commerce Clause, etc. We're going to turn to the Bill of Rights in just a bit and explain a couple of things about that. The Constitution that was sent out to the states to be ratified was Articles 1, 2, 3, and so on. There was no Bill of Rights at all. I mentioned this previously, but I want to dig a little deeper. There was no free speech, no freedom of religion, nothing in the original Constitution. Now, there was a big debate about that during the Constitutional Convention, as I probably mentioned earlier. Madison and Hamilton in particular were opposed to the Bill of Rights. Madison's argument, Hamilton's as well, was we said in the Declaration of Independence that rights come from nature, natural law, not from kings, not from governments. If we put in the Constitution a list of rights, even important ones like speech, religion, and so on, people are going to think that it's the government, the federal government, that gives us these rights. And we don't like that. Furthermore, someday, if a right that's important to the people, a natural, inherent right, is not in the Constitution, people are going to argue, well, it doesn't exist. And boy, were they right. They were 200 years ahead of their time, and I'll tell you that story later. So, they were against the Bill of Rights. The framers agreed, let's just get the Constitution out to the people, get it ratified to see if we're even going to form a government. And if we do form a government, then we'll take up this issue of the Bill of Rights later through amendments. And Madison agreed to that. I'll come back to that. So, the Constitution sets up in a process for amending it. I mean, the recognition is that from time to time things do change and we need to amend it. In fact, Justice Scalia, in making his argument for the original intent of the framers, when people would say, but you're advocating for a state of mind from 200 plus years ago, his comeback, which was pretty good, was, I'm not saying you can't change the Constitution, but do it through the amendment process. Don't just do it because some court felt like it. The political winds change. Not a bad argument. The other thing that's interesting is the process they put in place for amending the Constitution is hard. And it was deliberately hard. And Madison said so. He said it should be hard. If we make it too easy, 51%, then we're going to be having zillions of amendments, and it's back and forth and back and forth. We should only amend the Constitution when there's a really big deal. Amazingly, to this day, we have only 27 amendments, and 10 of them, the Bill of Rights, were adopted within the first couple of years of our nation. We don't amend the Constitution very often. In fact, it's been almost 25 years since the last one. And I think this is a good thing because France, where I've taught several times, France has only had a constitution this last iteration since World War II, and they've amended the Constitution, I don't even remember, but way more than we have because it's easier to amend it. The last amendment, the most recent that went through and was ratified, was the 27th Amendment. And this is the 27th Amendment. And you can see what it says. And I'll translate for you. It says that Congress, if Congress votes itself a salary increase, that increase shall not take effect until after the next election, so that the people can vote the rascals out who voted themselves a raise. Kind of interesting. This was proposed in 1789 by James Madison, and it was voted down by Congress. They didn't like it. And 203 years later, it was adopted verbatim, which is, to me, just amazing. By the way, I kind of zipped through the amendment process. I think it is important. Let me just reiterate this. For a constitutional amendment to be adopted, it requires both houses of the U.S. Congress to approve it by 2/3 margin. It is then sent to the states, and 3/4 of the states must approve it, which with 50 states, that means 38 states. Really tough to get it through. So, what happened was the Constitution was ratified. In spring of 1789, our new government began, federal government. George Washington is the first president. April 30th, 1789, he's sworn in. And then the first Congress is sworn in. James Madison was a congressman from Virginia. He had been offered a position in the Washington administration, and frankly could have had a much higher position than being a lowly congressman. But he wanted to be a congressman for a number of reasons. One of them was to introduce the Bill of Rights. Now, this is the interesting part. James Madison, during the Constitutional Convention in 1787, opposed the Bill of Rights. He opposed it completely. He didn't think it was necessary. Yet, in June of 1789, in one of the first actions in the Congress, James Madison stood up, all 5'4" of him, and proposed something like 17 amendments to the Constitution, containing many of the rights that we cherish today: freedom of speech, freedom of religion, and so forth. So what made him change his mind? Well, I read a lot about this. There were probably several things. First and foremost, Madison had told some people he really respected, like George Mason, who wanted a Bill of Rights originally, that let's just get the Constitution ratified, and then I promise you, if we get this ratified, we'll take it up in Congress. So part of it is I think he felt an obligation. Secondly, Jefferson, his close friend and mentor, was ticked off that the framers had not adopted a Bill of Rights. Jefferson was off in France or doing something else. And Madison was kind of chagrined by that, and I think he was sort of influenced by Jefferson. Madison began to change his mind. He began to buy Jefferson's argument that, okay, I get your point, but some rights are so important, we need to put them in writing. And the third thing, I think, is Madison decided, if somebody's going to do this, I think I'm going to be the one to do it. I'll do it right. It sounds arrogant, but it's actually true. He knew more about this stuff than anybody. I think he did pretty well. So he proposed 17 amendments, and Congress, as part of the amendment process, tweaked it, revised it, moved some things around, edited a few, dropped a few, and it cut it to 10 amendments, and thus the Bill of Rights is the first 10 amendments to the U.S. Constitution. That's why we refer to it as the First Amendment, Second Amendment, and so on. I just want to make a quick point about a couple things before we move to some of the amendments. Madison was very concerned about the tyranny of the majority, and I think this is relevant in our current political climate. These wealthy, educated founders and framers were always a bit nervous about the rabble, about what some people would call the great unwashed. And that may sound cruel, but basically what they were concerned about is if we're going to have a democracy, boy, it's really important that the voters be informed and educated, and that's why they were both, Madison and Jefferson in particular, so big on education. And Madison was always afraid. He was a very calm person of riots and people getting carried away. And this is a quote by him. When he proposed the Bill of Rights initially in May 1789, what he's saying is what he's afraid of is the majority. Sounds kind of funny coming from a person who advocated democracy. The other thing I always like to point out is the Constitution is far from perfect. I get a little carried away about the Bill of Rights and what a brilliant thing the Constitution is and the framers, but I put this slide in here to calm me down a little bit and remind us that, remember that all men are created equal language in the Declaration. Well, Jefferson really did mean that. And what he meant by it was all white men. Oh, all white men of property. Because the view of the time of those in power was only white men were citizens and could vote. After all, African Americans were considered not even people. They were considered property, at least in the slave states. And certainly women couldn't vote. When could women vote for the first time? This is kind of a good one to jot down. Women could not vote in federal elections until 1920. Something like the first 28 or so of our presidents were elected without a single vote by women. And it's really pretty shocking. Native Americans were treated horribly, of course. African Americans were not even, in the Constitution it says they're 3/5 of a person, and that had to do with politics and how you determine the size of a congressional district. It's a very, very long story, but the southern states said we're not going to ratify the Constitution because you northern states have more people. We're going to get creamed in Congress. And so they came up with this cockamamie compromise that slaveholders could count their slaves 3/5 of the slave as a person for determining the size of a 30,000 congressional district. So for the first many years of our nation, the southern states had a disproportionate representation in Congress, disproportionate in terms of the voters, because African Americans couldn't vote. It gave slaveholders enormous power. It's one of the real ugly incidents in early our history. So anyway, it took a while for some of these things to get sorted out, and we're still struggling with these things. And one of the great ironies, I live in Virginia. I've been to Monticello in the last year at least twice. I was there recently. Jefferson is an amazing man. This is his house, Monticello. It's one of the most visited homes in America, outside Charlottesville, Virginia. This is Montpelier, which I've been to once many years ago. This is Madison's home, about an hour, 45 minutes from Jefferson's home. And then the third of the triumvirate of the great Virginians is Mount Vernon, George Washington's home. Now, all three of these Virginians, founder framers, three of our first four presidents of the United States, were great men in their own ways. But the one thing they all had in common is they owned slaves. The reason they had these massive homes and massive estates is slaves. At Monticello now, that story is told quite well. Here is one of the ironies, and this is something I think every American should know. One of the very few of our early founders and framers, and the only one of these three men who freed his slaves, was George Washington. In his will, he freed his slaves, effecting on his wife's death. Okay, but on his wife's death, his hundreds of slaves were freed. What makes that even more amazing is it wasn't until the Civil War 60 years later that for the first time African Americans could be freed in general. It was against the law of Virginia to free your slaves voluntarily without permission of the Virginia legislature. And that was true until the Civil War. So it made Washington's actions even that much more amazing. Now, Jefferson freed a couple of his slaves, but the vast majority of them he did not. And probably it was because they were his family members. And some of you know that story. But for quiz purposes, George Washington is the only one who freed all of his slaves. Now, as we go through the specific amendments, which we're going to start shortly here, one thing to keep in mind is this concept that there are some of our rights that are fundamental, so fundamental constitutional right. Some rights are just statutory, but the Bill of Rights, those rights are fundamental. They're the biggies. If the government, federal, state, local, passes a law restricting your fundamental constitutional right, that law is presumed unconstitutional. That means when you go into court, the court must can only uphold the governmental restriction if the state can demonstrate to the court that it had a compelling governmental interest. That's the phrase. What it means is a really, really good reason for that law. And if the right is not fundamental, then the right is presumed constitutional. So if you have a statutory right, the presumption in court is that the law is constitutional, and you have the burden of proof to overcome that. If, however, it's a fundamental right, the burden of proof is on the state. And as you will see as we go through some of these rights, this is a pretty big deal. Now, just a quick point. Are there any absolute rights in the Constitution? The reason I posed this is several years ago, there was an incident on campus at WSU. It was kind of ugly, involving some confusion over some free speech student protests. Very long story. But one of the student leaders who was very upset with the university's decision on something, and I didn't know the student, sent me an email saying, I understand from some students that you teach law and that you talk about Constitution and free speech and so on. He said, my question for you is this. Isn't it true, aren't I correct, that we have an absolute, his phrase, absolute constitutional right of speech, free speech? Meaning, basically, the government can't prevent you from expressing yourself. And in my email back to him, I began by saying there are no absolute rights. So, this is a big thing to know. No right is absolute. All rights must be balanced against the rights of others. Thomas Jefferson allegedly said, my right to swing my fist or arm in the air ends at your nose. My right has to be balanced against your rights. Now, some rights are treated almost absolute at times, it seems. And some rights are really, really important. But I want you to be clear, there is no such thing as an absolute right. What we're going to do now for the remainder of this lecture is begin to talk about some of the specific constitutional amendments. Now, as I said, part 2 is entirely about some of the Bill of Rights. So, first one is the 8th Amendment. Well, we're not going to go in order, obviously. 8th Amendment, right there. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. For each of these amendments, I want you to think in terms of what were the framers thinking about, framers and founders, because this was actually in Congress. What were they thinking about? What was their concern they were trying to address? Well, this one pretty clearly comes from the fact that the view had been that under England and other legal systems, that sometimes people were given a prison sentence or death penalty that was not appropriate. It was way more than was necessary. And cruel and unusual, it's pretty clear what that was referring to. They didn't want people tortured to confess. And we still deal with that issue today. The big issue that I want to focus on right now, though, is the death penalty, because that's the thing we're arguing about today. I mean, yes, there's a torture issue with Guantanamo and some other things. But for American citizens, generally, torture is not a big issue, hopefully. The big one is the death penalty. So I pose to you the question, is the death penalty cruel and unusual? Well, we know that the framers did not think so, because if they considered the death penalty cruel and unusual, they would have banned it, and they didn't. So the courts have struggled. This is an example of the interpretation of the Constitution. There have been many people advocating that the court should strike down the death penalty in all the states. Well, throughout our history, and even currently, the death penalty is up to the states individually. They can have it or they don't have to have it. But the court has weighed in a few times about some constitutional issues. Now, I'm going to go through these next 2 or 3 slides very quickly, so take good notes. In the early 70s, in Furman versus Georgia, the U.S. Supreme Court did not strike down the death penalty completely, as cruel and unusual, but did say that it was very concerned about the way some states were imposing it. In other words, the procedure for the death penalty. And basically, the Furman case put a moratorium on the death penalty in the United States. Nobody could execute anybody until further notice. So many people on death row at that time got off death row, including this fellow named Charles Manson. Then a few years later, in Gregg versus Georgia, the U.S. Supreme Court said, well, we've been thinking about this. On further review, somebody threw a red flag apparently on the field and said, on further review, we're going to say that the death penalty can now be re-implemented, but all the states are going to have to throw out their old statutes, and if they want to keep the death penalty, they need to implement new statutes with some new procedures. And the big issue was the jury process. Before, some states allowed the jury to determine both guilt and death penalty in the same verdict process. The court said, no, 2 different stages. It could be the same jury, but it has to be 2 different stages. Guilt, then later, if necessary, whether life or death penalty. So since 76, the point is states have had to, if they want to have the death penalty, come up with new statutes. Some did, some didn't. Many did. I used to cover the number of executions that have occurred since 76, but obviously that changes daily, especially in Texas. So I'm not kidding. Texas is up well over 500, way more than any other state. And but this will give you a sense. This is sort of a current map of the states that have the death penalty, which is the blue states, and red states. States with the death penalty, the red states. States in blue do not have it. That is, but they never adopted it again, or some of them had it after 76, and then in recent years have revoked it. So the blue states, the light blue states, no death penalty at all. And then there are a couple states, looks like 4, that have the death penalty in the statutes, but the governor has initiated executive orders putting a moratorium on it, which means don't do it. There has definitely been a movement in recent years towards doing away with the death penalty. So what about Kansas? Where does it fit in all this? Kansas was one of the last states to execute anybody before the moratorium, and these guys were pretty famous. They were the last people executed by hanging in the United States. The guys on the left, Hickok and Smith, were the murderers in the family out in western Kansas that became the basis of the book and the movie In Cold Blood. And they were executed by hanging. And then the guys on the right were executed the same summer in Lansing. They went on a murder spree in several states. Their names were Latham and York. So, anyway, In Cold Blood came from that story, the guys on the left. But here's the thing about Kansas. Kansas did not get around to re-implementing the death penalty until 1994. Now, okay, I don't know why it took them so long, almost 20 years. But the interesting part about that, BTK, Dennis Rader, the Wichita Vine Torture Kill Killer, did not get the death penalty, in part because they couldn't pin any murders on him after 1994. So the most he could get was life in prison, which is what he got. Now, interestingly, in 2004, the Kansas Supreme Court struck down its own death penalty, the Kansas death penalty statute. And then a couple years later, the U.S. Supreme Court said, no, it's fine. And you can do that. The U.S. Supreme Court said, look, Kansas, you said it was unconstitutional, federal law. We are the final arbiter of constitutional law, and we say it's fine. So Kansas does have a death penalty. But here's a good thing for a quiz. How many people has Kansas executed since the summer of '65 when Latham and York and so on? The answer is 0. 0. We have a number of people on the death penalty, but we haven't executed anybody. Then the last thing we're going to talk about is the Second Amendment. Now, the Second Amendment has been in the news a lot lately. This is gun control. This is the right to keep and bear arms. Incredibly complicated, incredibly controversial. All of these things we're talking about are controversial. The Eighth Amendment, the death penalty, very controversial. Strong feelings on that. This one is as well. Again, I'm just trying to explain the current landscape on constitutional and what the courts have held. Second Amendment, a well-regulated militia being necessary to the security of a free state, comma. That's an important comma. A well-regulated militia being necessary to the security of the free state, comma. The right of the people to keep and bear arms shall not be infringed. What does that mean? Now, let's go back to the strict scrutiny test. This is where it comes into play. If I, as an individual, have a fundamental constitutional right to own guns, and the government tries to restrict that right, the strict scrutiny test is applied. That restriction is presumed unconstitutional, and the state of Kansas, let's say, could only win that battle and take my guns if it has a compelling governmental interest to do so. And that's how it works. If, however, the Second Amendment does not give me as an individual human being a fundamental right to keep and bear arms, if it belongs to the militia, which is what was argued, then it's not a constitutional right, it's a statutory right of the individual, and that restriction is presumed constitutional. Incredibly, until 2008, the U.S. Supreme Court had never resolved this question of whether this right to keep and bear arms is a fundamental right of the individual or the militia. So, in these two cases that I've cited there at the bottom of the screen, the U.S. Supreme Court had to decide that question. Does the right belong to the individual or to the militia? Now, again, there are no absolute rights. No one, that is, who really understands the constitutional issue, no one has ever really said that the government can take all your guns or that the government can't take any of your guns. I mean, you can't have a nuclear weapon in your basement or many other types of weapons. And that's because your right to keep and bear arms has to be weighed against the safety of other people. But in these cases, these two cases, the U.S. Supreme Court held, this is important, that the right to keep and bear arms belongs to the individual, that the individual has a fundamental right. Thus, the strict scrutiny test applies. Thus, it's harder for the government to restrict gun ownership and gun possession than it otherwise would be. So it was a major ruling in just a few years ago. The curious thing, it goes back to this thing about the militia. And in this D.C. versus Heller case, the U.S. Supreme Court quoted James Madison and said Madison wrote the Second Amendment, and he was a pretty smart feller, and he was usually very careful with his language. He was a brilliant writer. He must have had a reason for this phrase, a well-regulated militia. If he really intended to just be the right of the individual to keep and bear arms, why didn't he just say that? What's with this militia stuff? And what the court concluded is that what Madison was probably trying to do was, in effect, to explain to the American people, you know, this keep and bear arms thing is really important, but it's not just to shoot ducks. It's not just to shoot targets. It's because a militia, a state militia, state National Guard, is really important. And we certainly don't want to deprive the citizen soldier of the right to keep and bear arms for the sake of militia. Now, where that came from was the Revolutionary War. And Paul Revere's right. And where Paul Revere was going out to warn some people because the British were coming to take the weapons of the militia. That's where it came from. There's no question about that. What some people today argue is that it's very outdated, and the National Guard, they have their tanks and everything, and that people at home are not really part of the militia anymore. So it's a very complicated issue. But here's where it is constitutionally. The right belongs to the people. The court pointed out, we the people, first phrase of the Constitution. And the other thing the court pointed out was that every other time the word people is used in the Constitution, and Madison wrote much of it, certainly the Bill of Rights, it clearly refers to the individuals, not people collectively as in the militia. So that concludes Constitutional Law Part 1.